welcome to another episode of That's Right. I'm your host, Chris Voss. And today we have Matthew Asbell, who's an intellectual property attorney and partner at Lippis Matthias. Matthew, thanks for being here, man.
Appreciate it.
Thank you. So, is it a ridiculous idea if you share with our viewers a little more about your business and your journey?
It's definitely not a ridiculous idea. Much like in your book and in your teachings, when you talk about negotiation, you apply it across all different kinds of situations, like a hostage negotiation versus a business deal, or even in a personal relationship. My practice in intellectual property law is about protecting reputation and the fruits of creativity across all different kinds of situations, multiple industries, even sometimes different legal regimes. So it kind of has a broad scope. My passion for it really comes from multiple experiences in lots of different areas in my life. I actually went to medical school. I launched an independent record label and an artist management agency, and coded and taught software in a corporate environment. So all these different environments kind of speak to different types of clients with different types of issues, but also tie in with different kinds of intellectual property, sciences or arts or technology, as an example. I've also had some interesting cultural experiences that impact my practice. As a teen, I got to live in different countries with families for short periods of time, and that's really informed my perspective. I tend to have a much more global view, try to be more culturally competent, and when I work with clients who are diverse individuals or diverse businesses, try to be mindful of their perspective and their needs. So I'm a partner at this firm. It's like a top 250 business law firm. And then on the side, because I don't have enough to do, I'm also an adjunct professor and a mentor. I speak, I write, and I volunteer in an organization that helps startups to navigate IP issues.
Wow. So, what are some common challenges your clients face?
So the normal challenges in intellectual property are about how do I obtain or own rights in different countries, but also how do I stop other people from copying or otherwise utilizing what I've created? And then how do I defend my clients against when other people raise issues about what they're doing? So it can really impact a business, and sometimes these are the most valuable assets of a business. There are some other challenges that are kind of interesting, more, I would say, aspects of human communication and thinking, which are a lot of, I try to help a lot of my US clients who have an understanding of US law as it applies. They try to import that or generalize that to issues in other countries, which doesn't really work very well. So I help reorient them and help them understand those differences. And then I also have clients that will hyper-focus on a particular risk they've identified. They kind of really think that that's the issue that needs to be resolved, but sometimes they don't see it in context and in the lay of the land, and help them to understand that perspective and how it might impact them on the positive or the negative, or some other risk that might be more important that they didn't realize. So those are some examples of the problems. Recently, a client of mine tried to register a trademark in the United States for a day of the year, a day celebrating human persistence called Never Give Up Day. And I was able he had several obstacles that were preventing him from getting that, and I was able to overcome that. So I guess it's apropos to say that I never gave up.
Very good. Yeah. All right. So, what strategies do you use to understand your clients' needs better?
Well, I'd say I've been practicing almost 20 years. I've kind of learned on the fly, but it is really about human communication. I mean, I think there are things that you referred to in your book and in your teachings, the sort of mirroring, paraphrasing back to clients what they say to me so that they can feel heard, and so that they can also know that I've understood. And I'm processing and I'm aligning with them. I will propose different scenarios and see how what's important to them as to what things they would want to respond to or not. I think about the nature of the questions I ask, whether they're open-ended or leading in some way. Sometimes I use the leading question to try to guide them, and the open question really to try to solicit the information that I need to understand it. Try to be thoughtful and communicative and responsive, and I don't know, something like that.
Right. All right, very good. So are you against sharing a time when you navigated a difficult situation for you or for one of your clients using tactical empathy?
I'm definitely not against it. And I love how you asked it. It's a struggle to identify a particular situation like that. I feel like if you utilize this, maybe I think you utilize it and you're much more conscious of how you use it. I'm less so. But the example that comes to mind is one where I had a client that was really facing a very frustrating situation. There was another company with the same name, or basically the same name, coming out of Japan. And they were doing similar types of services. And there was this risk of a big multinational litigation. We were going to have litigations in all different kinds of countries all at once. And they weren't direct competitors, so there shouldn't have been this fight, but they were bumping into each other. We were bumping into it for years because every time we would throw proposed terms of an agreement together and send it to the other side, to the Japanese attorneys, we would just get no, refused, the end. And we couldn't understand what was going on. And at one point, I sort of took a critical evaluation of all of their commentary and what they had said. And I determined, hopefully, I guess accurately, that they were misinterpreting the language. Some was translation, but some was really about the way in which it was presented maybe didn't conform to the way a Japanese attorney and a Japanese business person would look at it. So I had an epiphany. I talked about it with the client, and we agreed that I would rework this entire agreement, but not change any of the substance. All I did was change the order. And when I reframed it in an order which presented, here's what we're doing for you in a balanced way, here's what you're doing for us in response, and sort of a call and response way, we were able to resolve the whole thing, and the client was ecstatic, and we saved a lot of money. And I'd like to think that that was a use of tactical empathy. Maybe you'll tell me otherwise.
No, that's great. I mean, essentially, that's right moment, and that's right is when people feel heard and understood, like you mentioned earlier. They feel heard and understood. They say that's right, and because what you just said was the truth, in their perspective. So, can you share any other moments we've had? That's right. You were able to get it in your business or your personal life, so people who are listening to this can get a better feel for how it works in real life.
Sure. So this is an instance where we're navigating the nuances of trying to obtain rights from the US government. And I had a client who was trying to register a trademark in relation to coffee. No big deal. And they asked, after the fact, could I add in espresso? And there's a general rule with any kind of IP application that you can't expand beyond what you originally sought. They want you to stick to your guns, start with what you started with. You can only narrow it. The trademark office says, I'm sorry that this is an expansion. This is an impermissible expansion of your application. They refuse your application, which I thought was nuts. There's no way this is accurate, but that's their position. So kind of gathered my wits, picked up the phone, and I called the attorney in the trademark office. And I like to think I used the that's right and tactical empathy kind of approach. And I said, so is what you're saying that adding espresso into this application is going beyond the scope of what we originally filed? Yeah. And so if I were to add now something like black coffee or Colombian coffee into this application that covers coffee, that would be beyond the scope? That's right, he said. And we ended the call. I was thinking he was nuts, and I'm like, okay, we're preparing to fight this if the client's willing to do it. 2 minutes later, he picks up the phone, I've reconsidered. You can add espresso into the application. So
Well
I
done.
just registered recently.
Yeah. Well done. So if someone wants to learn more about you, get in touch with you, find out how they can work with you, where should they go? Where will they find you?
So they can always go to my law firm website, which is lippes.com, where I have a profile. But I
Lippes is L-I?
lippes.com. But I also have a personal website at matthewasbell.com, which is MATTHEWASBELL.com. And that will have more. That will have more information about speaking engagements and articles I've written and videos and things of that nature. Hopefully this interview at some point.
Yeah, all right. All right, well, Matthew Asbell, it's a pleasure. I know people got a lot out of what you had to say today. Thank you very much.
I really appreciate it. Thanks for having me.